Актуальним. Шановні колеги, я запрошую до слова доктора Євгенію Курзінскі-Зінгер, наукового співробітника Інституту іноземного та міжнародного приватного права імені Макса Планка. Тема виступу «Імплементація спільного доробку Європейського Союзу в Україні. Уроки юридичних запозичень».
Ladies and gentlemen, first of all, I would like to thank the organizers of this conference and to say that I'm really very happy to be again in Kyiv and that I like your city very much. It's really a wonderful city. Well, the title of my presentation is The Implementation of the EU Acquis in Ukraine, Lessons from Legal Transplants. As we all know, the association agreement between the EU and Ukraine, which was concluded in 2014, obliged Ukraine to an extensive approximation of national legislation to European requirements with the aim of achieving the economic integration of Ukraine into the EU internal market. The next slide, please. This obligation reflects the idea that market integration is not possible without a certain approximation of legal standards. Therefore, the aim of the obligation to implement the EU acquis is settled in the association agreement is to create in Ukraine similar market conditions as in the EU and to promote the Europeanization of Ukrainian law. Insofar, this process is a part of a value-based Europeanization of the entire Ukrainian society. In terms of specific values, the preamble and Articles 2 and 3 of Association Agreement enumerate especially respect for democratic principles, the rule of law, good governance, human rights and fundamental freedoms, human dignity, and a commitment to the principles of a free market economy. In this sense, the creation of similar market conditions presupposes a change of the entire legal and institutional environment. The Europeanization of private law, which will be addressed in this presentation, is only a part of this process. According to the Association Agreement, the Europeanization of Ukrainian private law should proceed by means of reception, which is a process of individual rules, institutions, or even whole areas of law being borrowed by one legal system from another. The next slide, please. Yes. So far, the Association Agreement obliges Ukraine to implement diverse European legal acts into its national legal system, especially diverse EU directives which have to be transposed into Ukrainian law. Such a borrowing of legal provisions or legal ideas, a notion which is addressed in a really huge amount of research articles as so-called legal transplants, is a well-known phenomenon. The historical archetype of a reception process is held to be the reception of Roman law in Europe. In the present era, the reception of provisions of American corporate law in German law offers an example of successful legal transplants. The main example, however, and the most interesting in the present context, is the ongoing approximation of the legal systems of European countries as a result of efforts of the European Union to create the single market. However, it has also been observed that in many cases of legal transplants, there is a gap between the formal law on the books and the law in action. Legal transplants have even been held to be impossible because of the cognitive dimension of the law, which causes the original rule to necessarily undergo a change while being implemented in another legal system. In any case, the modern research on legal transplants proves that the reception of legal provisions does not necessarily create in the borrowing legal system a rule which would be identical to the rule the borrowed provision creates in the original jurisdiction. Especially in developing and transition countries, the reception process is a complicated and often ineffective one. The recent research on legal transplants, especially regarding transition countries, questions in particular the assumption that the legal harmonization will result automatically in an improvement of legal institutions. Indeed, the European integration of Ukraine faces problems which are typical of the legal environment encountered in a transition country. In particular, there are difficulties in the formation of the institutions that would meet European standards, such as an independent and well-educated judiciary, the rule of law, good governance, and a low level of corruption. We all know it very well. Without a doubt, these conditions influence the legal standards the Ukrainian market can offer its participants. However, these institutional problems are, in my opinion, not the only obstacle for the approximation of Ukrainian law, and especially the substantive private law, to the European standards. The observation of legal transplants, especially in transition countries, gives evidence that the implementation of foreign legal provisions or legal institutions in international legislation can produce a wide range of outcomes. Especially Georgian law provides in this regard very interesting examples. And Georgia, as well as Ukraine, is a country which is orientated towards the European Union and is aiming at a Europeanization of private law, including the implementation of the EU acquis. It should be mentioned that the Georgian Civil Code was elaborated in cooperation with German scholars and is based on the German Civil Code, the BGB, making many, although not all, provisions to legal transplants as well. The selected case studies on Georgian law, which were conducted in course of a project on legal transplants at Max Planck Institute, showed that legal transplants can produce a very diverse outcome. They could be ignored by the legal order, as it seems to be the case in Georgia in regards to consumer law and private international law. The borrowed provisions could further be changed in the course of the interpretation or the interaction with other provisions of the national legislation, which was the case for some provisions of the property law. However, an effective transplant, which produced rules very similar to the original ones, could also be identified. A further possible outcome, which could occur in the course of the implementation of the EU acquis, would be a situation in which a previous rule of national legislation was replaced by a provision which is less appropriate for meeting the regulatory need at issue. In such case, the transplant is not just ineffective, but really harmful. In addition, a legal transplant can develop into a legal irritants which could conflict with the recipient legal order and influences the legal or even social discourse. So summing up, it should be understood that the outcome of a legal transplant can fluctuate widely. The empirical data on legal transplants in transition country indicates that the most effective transplants, in other words, those most easily accepted by the recipient legal order, are transplants which solely develop the existing regulations and do not intend to initiate radical changes, or transplants which create a regulation for tabula rasa, which have a similar effect. In the project which was referred to earlier, this observation was supported in particular by a case study on rights of minors in Uzbekistan. The implementation of the United Nations Convention on the Right of Child on Uzbek family law was shown to be an effective transplant. And this outcome could be explained by the fact that the implemented provisions did not conflict with basic values of Uzbek family law, which are rooted in Soviet family law and already correlated with the values of the convention. By the contrast, the greater the differences between the values and structural peculiarities transported by legal transplant and those of the recipient legal order, the lesser the effectiveness of the transplant. Next slide, please. To explain this effect, it is important, next slide please, no, the previous one. No, the previous one. Yes, this one, thank you. To explain this effect, it is important to focus on law as a cultural complexion with a social dimension. A comparative researcher should be aware of the fact that the legal provisions do not exist in a contextual vacuum. In the original legal order, the transplanted legal provisions has been a subject to interpretation and legal discourse which have been deeply influenced by factors inherent to the original legal order, such as the interaction with other provisions, legal methodology, values immanent to the society, and the social structure. Not all of these factors are obvious, due to the fact that every legal system contains a great amount of implicit legal knowledge and understanding. The silent dimension of law has enormous effect on the application of legal provisions and its impact on the legal system as a whole. In this sense, the law is similar to an iceberg, such as you can see at the picture. If we look at the provisions of legal acts only, we see not more as a very small part of the entire legal order. After being transplanted into another legal environment, the legal provision will be influenced by the corresponding elements of the recipient legal order, including its silent dimension. Therefore, the efficiency of the legal transplants depends on the similarity between the original and the recipient legal order. An effective legal transplant is correspondingly easily possible if the original and recipient legal order have much in common, especially if they share the same values and legal approaches. Conversely, the reception is likely to be ineffective if the legal transplant conflicts with the values of the recipient legal order. For this reason, the key to understanding and predicting the outcome of a reception should be an analysis of the relationship between the legal transplant and the recipient legal order. Considering the provision of the EU acquis as being legal transplants for Ukrainian legal order leads to a question: what requirements should the Ukrainian legal order fulfill to enable an effective implementation of this provision? In other words, what is the specific characteristics of the legal orders of the European countries which enable an emergence of the acquis communautaire? Next slide, please. However, the most eye-catching detail of the European area of justice is the enormous diversity of legal cultures. Comparative legal research points to the differences in structure and approach, as well as to the differences between rules. These differences challenge the attempts to state the principles of European private law or even to unify it, be it in form of draft common frame of reference, principles of European contract law, a common European sales of law, or a codification of European private law. On the other hand, these differences should not be exaggerated. Especially for contract law, it has been held that it differs more in the formulations and techniques than in results, including a wide concern on how the law should be. It was also held that the fragmentation of the European civilian tradition generally appears to be, much more often than not, historically contingent rather than determined by cultural traditions. Actually, the European legal orders share a long common legal development. Initially, Roman law has constituted the foundation of the jus commune, prevailing in the medieval and early modern Europe. Then, in the epoch of the Enlightenment, this foundation was enriched with principles of natural reason, which constituted values that are still immanent to the European legal orders. The revolutions of the 19th century followed, removing the old feudal structures and promoting ideas of democracy, liberalism, and independent national states. As the consequence of this development, some of the older codifications of private law established essential principles characterizing the private law of European countries until today. Under such basic principles, one should name the freedom of contract and testation, the recognition of private property, equity before the law, and the autonomy between public and private domains as the general organizing principles of the social model. In this sense, the European legal orders share the same basic values. This common core of European private law is additionally based by the similarity of economic and social conditions in the EU. However, for European legal scholars, this common core of the legal culture is likely to be so obvious as to not require an exact definition of its significant criteria. The common values and basics already exist and do not need to be discussed in the course of the unification debate. For the Europeanization of Ukrainian private law, the situation could be different. The association agreement seems to presuppose that Ukrainian private law already shares the common core of the European private law. However, it seems worth questioning this presupposition. The next slide, please. The development of Ukrainian private law differs significantly from the European model. Like the private law of the most CIS countries, Ukrainian private law has to a great extent developed from Soviet civil law. Insofar, the modern private law of Ukraine has been deeply influenced by its Soviet heritage. However, as a part of this Soviet legal tradition, it is also rooted in the legal tradition of the European, especially German civil law. These roots go back to the law of the pre-revolutionary Russian Empire, in particular to the pre-revolutionary draft of the Civil Code, which was never enacted, but which influenced the civil codes of the Soviet republics. However, despite the semantic similarity that existed between individual civil code provisions of Soviet republics and the civil code provisions of Western European countries, Soviet civil law was not a part of the European legal tradition. The initial core of private law in Soviet legislation was overwritten by the Soviet ideology, which deeply influenced the legal tradition and in particular the legal methodology. The above-mentioned basic values and principles of Western European private law, such as freedom of contract, recognition of private property, and autonomy between public and private domains, contradicted Soviet ideology and were not inherent to Soviet private law. After the collapse of the Soviet Union, Ukraine, as well as other successor states, initiated reforms to adopt the legislation of the requirements of the market economy, which provided the civil law with a liberal approach. These reforms changed the legislation significantly, but they could not completely replace the previous legal doctrine that was rooted in the Soviet law. In fact, the liberal ideas and approaches are likely to complement the legal discourse, competing with the old Soviet approach, but not building the basic values and principles of contemporary Ukrainian law. The coexistence of contradictory and competing approaches, doctrines, and ideas is characteristic to some degree for all successor countries of the Soviet Union. The private law of most of these countries is very much like the picture you can see. One can observe Soviet heritage, the fact that the core of the private law is rooted in the pre-revolutionary legal thinking and the new Western approaches as well. So far, it has to be realized that a mechanical implementation of the EU acquis will not automatically approximate Ukrainian private law to the private law of the European Union. The implementation of the acquis provisions in a legal environment which does not share at least the same values and basic concepts is likely to lead to a situation where real approximation to European law will not be achieved. In this sense, a simple mechanical implementation of the EU acquis will not meet the goals of approximation obligation as stated above, but rather let the private law look like the picture on the next slide. The Europeanization of Ukrainian private law, in fact, requires its access to the common core of the private law of the European area of justice. In this sense, the approximation should comprise the silent dimension of law, especially the implicit knowledge and understanding, as well as the legal methodology and the values. The methodology of such an approximation is really far from obvious. As stated above, there is actually no consensus about what elements are essential components of European private law's common core. Furthermore, the preceding discussion on the possibility of legal transplants indicates a close connection between the basic concepts of law and society. This law as a mirror theory, which was already mentioned by Professor Bazidu, emerged in different contexts and epochs, and it was applied, for example, by Montesquieu, Marx, Savigny, and in the modern context, Legrand. The general implication of this theory is the impossibility of achieving social engineering by law reforms, and also the impossibility of rapidly accomplishing radical law reform. This implication has, however, been rather controversial until present. In particular, the discussion between Savigny and Thibault concerning the proposed codification of German civil law in the 19th century has often been referred to in recent times in course of the debate on the unification of the private law in the EU. The experience from European codifications of the 19th century could, however, be a source of inspiration for the methodology for transforming post-Soviet legal orders. Most of these codifications were legal acts which documented and perpetuated the transformation of the societies from feudalism to capitalism, similar as the ongoing process of transformation of the law of the post-Soviet countries. The main factor that contributed to the success of the national codifications in the 19th century has been identified as there being a manifestation of a tradition of legal scholarship, so their preparation usually took a long time and was facilitated by the experience of well-established and well-documented legal doctrine. In my opinion, the consequence of this experience is that the elaborating of a new legal doctrine would be a crucial point for the transformation of the civil law in the post-Soviet area. At the given moment, all the countries have enacted civil codes that can deliver a legal framework for the market economy. It is mainly the legal thinking that is deeply rooted in Soviet heritage. The change in the inherited approaches requires a value-based discussion, one which would see the civil law as an instrument to balance different interests and to enable the participants of the market to realize a self-determined protection of their interests. A very important part of this process is access to European legal discourse, something which is more important than any legislative reform. Thank you for your attention.
Дякую шановному доктору Курзінські-Зінгер. Тематика надзвичайно актуальна. Ви знаєте, в мене думка така промайнула. Для України надзвичайно важливим є питання про те, щоб сформувати своєрідний алгоритм допустимих трансплантів, оскільки, як правило, все навпаки. Ми робимо якісь реформи, якісь закони створюємо, а вже після цього думаємо про якусь методологію, єдність цінностей тощо.